South Puratan Patit, Divakar Purai and others, East Ahlad Mato, West Puratan Patit of Smriti Day, and local name has been mentioned as Sindhuar Bay. And let's here, down same page, issued by Freedom Commission AK Par and
Maybe with the passage of time, the boundary of the property would also change. If somebody else purchases the next door property, then boundary, this Khatyan was prepared when? Around a century back. Right? And this is the boundary. But plot number is the same.
But that is the whole, and that's
Absolutely.
the non-consideration of the absence of the
We'll take care of that.
Of the same.
We'll take care of that.
Yes.
You are relying upon some judgment?
Yes, I have given the paragraph 24-25 is on that only. The inner suit for possession. 24 and 25 only.
For the learned counsel appearing on behalf of the applicants. This appeal has been filed against the judgment and decree dated 18/8/27 within bracket decree signed on 1/9/27, 18/8/2017 within bracket decree signed on 1/9/2017, passed by learned Principal District Judge Civil Court Bokaro in Civil Appeal number 31 of 2016, affirming the judgment and decree dated 30/6/2016 within bracket decree signed on 14/7/2016, passed by the learned Civil Judge within bracket Junior Division bracket close Bokaro in title suit number 32 of 1994. The title suit was decreed in favor of the plaintiffs on contest. The learned counsel for the appellants has submitted that though there are concurrent findings recorded by both the courts, but the proposed substantial question of law as filed on 30/4/2025 are to be considered in view of the fact that the trial court judgment as well as the appellate court judgment are perverse. The proposed substantial question of law are as under. The learned counsel has submitted that since the matter was relating to Exhibit 1, the records of the courts concerned have been called for by this court to peruse Exhibit 1. The learned counsel, while referring to Exhibit 1, has submitted that the Exhibit 1 only refers to the land in Mauza Chandra, check करिएगा. Mauza Chandra, थाना नंबर 193, खाता नंबर 165, plot number 4207, area 19 district, but does not provide the boundary.
Mentioned as Gothar.
And the property has been mentioned as Gothar,
Right,
BAID. The learned counsel has submitted that there are two adjoining properties. One is Gothar Bag and other is
Sinwar.
Sinwar Bag in plot number 4207, each having area of 19 decimal, and as per the written statement filed by the defendants, the property was wrongly mentioned in the sale deed, within bracket Exhibit 1. She has referred to the written statement and has submitted that it was the specific case of the defendants that the property was sold by Venu Mahto in the year 1954, known as Gothar Ban, situated near the house premises of the plaintiff, though the plot number and khata number of that land was wrongly mentioned in the deed in favor of the father of the plaintiff. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2024 bracket close 3 SCC 224 paragraph 24 and 25 to submit that suit for possession has to describe the property in question with accuracy and all the details of measurements and boundary, and in absence of such details, the suit for possession cannot be identified, and therefore the suit has to necessarily fail. After hearing the learned counsel for the appellant and upon going through the impugned judgments and the records placed, this court finds that as per the specific case of the plaintiff, the property in khata number 165, plot number 4207, area 19 decimal of Mauza Chandra Thana number 153, PS Chandra Kyari, district Bokaro, was described in Schedule A of the plaint. The said property was recorded in the name of ancestor of Beni Mehto and others, and it came in their exclusive possession. And while they were in possession, the entire plot was sold to the father of the plaintiff, namely Budru Go, for a consideration through registered sale deed dated 6/7/1954, and possession was delivered. The sale deed is Exhibit 1. Upon perusal of Exhibit 1, it is not in dispute that Exhibit 1 does not mention the boundary of the property. However, it mentions the plot number 4207 and area 19 decimal thereof, and total area 19 decimal. The Schedule A of the property, of the suit property, is quoted as under. The relief prayed for by the plaintiff in the suit is also quoted as under. The schedule of the Schedule A has given the boundaries of the property, though in the sale deed the boundary has not been mentioned. The relief sought for was confirmation of possession with respect to Schedule A property and for recovery of Schedule B property after demolishing the structure made by the defendants, in spite of restraint order made passed under Section 144 CI. The Schedule B property is also the area to be recovered, the property to be recovered from the defendants has been mentioned in Schedule B property. However, as per the plaint, Schedule B property formed a part of the Schedule A property. So far as the defendants are concerned, they have stated that the plot number, they have specifically stated in the written statement that the property sold in the year 1954 within bracket Exhibit 1, he sold the property as Kotwara Ban, in which the plot number and khata number was wrongly mentioned. It was also their case that the land on the plot khata number 165 was in two pieces of Baid Khe in the nature, namely Kotwara Ban and Sindwara Ban, belonging to and was recorded in the name of one Janki Mehto in the CS operation, who died leaving behind two sons, namely Beni Mehto and Chandan Mehto. Chandi Mehto, and both sons of Janki Mehto inherited both the lands of Kotwara Ban, measuring an area of 19 decimal and Sindwara Ban measuring an area of 19 decimal. It was also the case that Sindwara Ban was figured as plot number 4207 and Gotwara band though figured as other than plot number 4207. It was also the case of the defendants that after execution of the sale deed in 1954, without the consent and knowledge and of co-sharer Chandi Mehto, when it came to the knowledge, then an objection was raised, and ultimately they entered into compromise, and Gotwara band was allotted to the share of Beni and Sedwara band was allotted to the share of Chandi. From the perusal of the judgments passed by both the courts, this court finds that no such compromise has been brought on record by either parties. This court also finds that
if there was any compromise, that should have come in the recital of the deed of 1980, by which they are saying that we have purchased the land. How they came in?
it is not there.
There is finding.
It is not there. You are nobody now.
Yes.
In
fact,
नहीं ऐसा बीच में मत बोलिए please. As many as 11 issues were framed by the learned trial court, which are as under. The learned counsel for the appellant has in particular referred to issue number 10 and 10. वो भी तो एक ही बात है ना. You have argued only issue number 10. Has in particular referred to issue number 10 and has submitted that the same has been wrongly decided by both the courts, and it is a specific case during the course of argument that in absence of boundary of exhibit 1, boundary of the property in exhibit 1, the suit could not have been decreed.
one more submission.
अभी कोई सबमिशन नहीं कर सकते आप. नहीं
पहले से proposed है इसमें एक और question.
नहीं आपका सुनिए मैडम, आपको 1.5 घंटा से सुन रहे हैं. Did I stop you?
No, but that question needs to be referred to C.
Why do you how do you say it is need to be referred in the midst of the dictation? क्या ऐसा चीज है सी में?
नहीं, C में है वो. PW1 से deposition laws regarding there being two lands and admission of the possession of the defendants. That is the question. C.
In the midst of the dictation of this order, the learned counsel has also referred to substantial question of law as framed in the memo of appeal, which is proposed substantial question of law number C, which is as under. This court finds that the learned court considered the issue number 16789, 10 and 11 together and recorded the main contentions between the bone of contention between the parties as under. ये internal page 71 में आएंगे. The learned court was of the view that in view of the learned court has thereafter considered all the materials on record, and the learned court considered that so far as the plaintiffs are concerned, they had to prove that they have acquired right title interest by virtue of registered sale number 9045 dated 6/5/1954 within bracket Exhibit 1, and they are entitled for confirmation and recovery of possession over the sued property, and considered the various materials on record, including the evidence of PW1, and ultimately recorded finding in paragraph 16 इसका पार्ट ही तो करना है as follows. ठीक है. Thereafter, the trial court considered the evidences of the defendants, documentary evidence, the oral and documentary evidences of the defendant, and recorded in paragraph 18 as under. The learned trial court recorded that the initial burden, the learned trial court thereafter further considered the materials and held that the plaintiff had discharged the initial burden and the onus of proof shifted to the defendants to prove their alleged contention as raised by them in the written statement. And in paragraph 20, as many as 5 reasons have been cited by the learned trial court to hold that the defendant has not been able to discharge their burden. So far as the first reason is concerned, the learned court held that since the defendant had specifically pleaded the different boundary of the land of the plaintiffs and pleaded that wrong entry of khata number and plot number in the registered sale deed number 9045 dated 6/7/1952 has been mentioned, but no such proof was given by the defendants. Secondly, the argument of the defendants that they had purchased a different that the land purchased by plaintiffs are different land other than the plot number contained in the registered deed. The learned court was of the view that there can be no two same plot number under same mausa under the same khata number, and also recorded that the description of the land was duly recorded in the record of right. With respect to the same khata number and plot number. With respect, while citing third reason, the learned court cited the judgment of the Honorable Supreme Court in the case of Prem Singh and others versus Birbal and others, reported in bracket 2006, bracket close 5 SCC 353, and held that and observed that it has been held that there is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law, and the onus of proof would be on the other person to rebut the same, rebut such presumption. The learned court also recorded that the defendants have completely failed to explain as to how the vendor of the defendants transferred then 17 decimal of land, though the vendor number 1 of the defendant had got only 9 decimal of land through the deed of the year 1975, and so the deed of the defendant also cannot be said to be a valid one with respect to the suit land. By observing that nobody can transfer a better title than what he has. And also recorded that the defendants have failed to prove their pleadings by adducing any cogent and required evidence to the effect that the son of Beni and Chandi settled their dispute by way of compromise on the ground that the son of Chandi could get the entire area of 19 decimal of plot number 4207. Fourthly, the learned court कोर्ट का बहुत छोटा सा है, उसको ऐसे कोर्ट कर देंगे. Then fifthly, the learned court held that the registered sale deed of the plaintiffs was never challenged by the defendant, nor they got the deed cancelled. No such suit was filed. Then the learned court also held that the plaintiff have got valid right title and interest over the suit property by virtue of registered sale deed number 9045 dated 6/7/1954 and was entitled for confirmation of possession over Schedule A land and also entitled to recovery of possession of Schedule B land after demolishing the illegal structure, if any, over it, and the plaintiff was entitled for degree of permanent injunction. This court finds that the learned court was of the view that the registered sale deed number 9045 dated 6/7/1954 was for an area of 19 decimal in connection with plot number 4207, and the same was, and the defendants had failed to prove that it consisted of 2 pieces of land and that there was a compromise in connection with the property. The defendants had also failed to prove that there was a compromise in connection with the property. it was the entire area of 19 decibel which was sold by Exhibit 1 with respect to plot number 4207. The learned First Appellate Court has also scrutinized the material on record and gave concurrent findings. This court finds that although the boundary of the property was not mentioned in the Exhibit 1, but in the schedule of the property the boundary was mentioned. In Schedule A the boundary was mentioned and the entire area of plot number 4207 was transferred by the Exhibit 1. This court finds that with regard to both the courts found no impediment with regard to identity of the property, and both the courts have rejected the plea of the defendants that the description of the property was wrongly mentioned in Exhibit 1, and also disbelieved and the case and the defendants failed to prove their case that they ultimately got the property through compromise. The judgment passed by the Honorable Supreme Court, reported in bracket 2024 3 SCC 224, does not help the appellant in any manner, as in the said case, a portion of the property was purchased and the details of measurement and as in the said case, the suit did not give the details of the property. In the present case, the details of the property with boundary has been mentioned in Schedule A as well as Schedule B of the plate. In view of the concurrent findings recorded by both the courts, after considering all the materials on record, this court finds no perversity or illegality in the matter of appreciation of evidence by both the courts, and no occasion arises for framing any substantial question of law. Accordingly, this appeal is dismissed.
Item 2, second appeal. Item 2, second appeal 274 of 2023.
कल भी पास ओवर हुआ था ना, आज नहीं होगा पास ओवर. You have read it? Yes. Why? You don't get time. Which file have you read? Sorry? Okay, pass over. Next question. आज से लेकिन कल नहीं चाहिए.
For hearing item 3, first appeal 201 of 2015.
Yesterday I could not appear because I was on election.
No, I was not looking for you. I asked her to prepare. And don't seek a judgment. I will not be there.
But she is not seeking that.
Not. You don't prepare your junior also how to argue your first appeal.
But she
You just sent her for argument. She never asked for time. She never asked for time. She started the arguments. And I told her that she's unable to argue, so I provided her the records or whatever.
This first appeal has been referred by the appellants against the decree passed by the learned court below. The partition preliminary decree has been passed by the learned court, holding therein that 1/8 share of the suit property as per Schedule A has to be divided equally among the plaintiffs and all the defendants here also. The present appellant number 1 and 2 are the sons of original plaintiff number 1 here also. And plaintiff number 2 is the daughter of plaintiff number 1 in the learned court below. And other plaintiffs number 3 to 7 are the daughters of plaintiff number 1. The husband of plaintiff number 1 has died in the year 1993. The suit upon which the partition was to be held by the plaintiff, the player, was with regard to 0.04 decimals of land, which has 2-story building civil structure and a shop in the ground floor. Altogether, 8 issues have been framed here also in the decree. We are basically aggrieved by issue number 3, 4 and 6. The findings which have been given by the learned lower court.
Which are those issues?
Issue number 3 is, your lordship, whether the suit is bad for non-joinder of necessary parties.
And 4?
Fourth is whether the entire land of the ancestral property are included in the suit or not. And 6, whether there is unity of title and jointness of possession amongst the parties over the suit property.
You are the defendants.
I was defendant number 1 and 2 before the learned court below. And the other defendants who are the daughters of plaintiff number 1, they have admitted
Supported.
in the
They have supported the plaintiff.
yes, in the written statement they have directly stated that all the amendments which have been made in the plaint, they are admitting the fact. In simple, they have only stated that they are admitting all the amendments made in the plaint. That was their stand. So Lordship would finally come to the plaint of the plaintiff before the learned court below.
Yes.
Your Lordship, they have categorically stated in para 8 of their plaint that the Schedule A property is still joint property of the plaintiffs and the defendants, and they are enjoying the same as per their convenience. Further, they have stated in para 9 that the defendants number 1 and 2 are enjoying and using the major portion than their 2 share each of the Schedule A property, depriving the plaintiffs to enjoy the same proportionally
In the same rate and proportion.
proportionally as per their share. The defendants number 3 to 6 enjoy the Schedule A property whenever they came from Sasural, and even on the request for proper use of property by the plaintiffs, the defendant number 1 and 2 never paid any heed to such request. Your Lordship, my contention is that with regard to whether the suit is bad for non-joinder of necessary parties, admittedly, they have admitted in the plaint, if your Lordship would see, that this particular property, the scheduled A property, used to belong, the name as per the Khatian, it belonged to one Dako Devi. Dako Devi is the mother of the husband of plaintiff number 1, that they have admitted in their claim that it belonged to Dako Devi. Dako Devi had 3 sons out of the wedlock. One is Nandlal Saha, who was the deceased husband of plaintiff number 1, and other 2 are Parmeshwari Saha and Ishwari Saha. As per their own schedule in the claim, they have admitted in internal page number 8 of Schedule A, if your lordship would see,
The genealogy.
the genealogy. Dako Devi Narayan Saha. Narayan Saha is the husband of Dako Devi. Nandlal Saha is the husband of plaintiff number 1. Parmeshwar Saha is alive. They are themselves admitting that he is alive. Ishwari Saha, they are themselves admitting that he is alive, the brother of Nandlal Saha. Now this scheduled property, since these plaintiffs belong to, they are governed by the Hindu Succession Act, so therefore your lordship, this particular property is governed by Hindu Succession Act. So my contention is that the learned court below ought to have exercised their power under Order 1, Rule 9 and Order 1, Rule 10 by adding these defendants, Parmeshwar Saha and Ishwari Saha, as even as performer defendants or defendants, because the plaintiffs have categorically failed to show that this particular property has been partitioned by way of exhibiting documentary evidence or by laying oral evidence. So therefore, it is hit by the principles of non-joinder of necessary parties, as because they themselves have admitted that Parmeshwar Saha is alive and Ishwari Saha, both the brothers of husband of plaintiff number 1, is alive, and since they themselves admit that they are Hindus, so they would be governed by Hindu Succession Act, and they should
Don't
have.
repeat, I have got it. Just a moment.
Yes, yes.
I take dictation side by side so that I do not forget anything.
Yes,
Just a moment. DT Razana, first appeal number 201 of 2015. This appeal has been filed by the defendant number 1 and 2 against the judgment dated 31/2015 and decree dated 12/2/2015 passed by the civil judge in bracket senior division number 1 Kodarma entitled suit number 11 of 2009, whereby the partition suit has been decreed and the plaintiffs have been held to be entitled for 1/8 share each in the suit property. The learning council has submitted, for the appellant has submitted that the suit property was to the extent of 0.04 decimal of land with building and shop thereon. The learned trial court framed altogether 8 issues, and the appellant is primarily aggrieved by decision in issue number 3, 4 and 6. The learned counsel has submitted that the plaintiff number 1 and 2 were mother and the widow and son, the widow and daughter, unmarried daughter of Nandlal Saha, and defendant number 1 and 2 were sons of plaintiff number 1 and Nanlal Saha, and defendant number 3, 4 and 5 were the 3 married daughters of plaintiff number 1 and Nanlal Saha. He has submitted that this aspect of the matter is not in dispute. He submits that the property was originally recorded in the name of Dako Devi, mother of Nanlal Saha, and it is not in dispute that Nanlal Saha had two other brothers, namely Parmeshwar Saha and Ishwari Saha, and after the death of Dako Devi, the property would have devolved upon all the 3 brothers, but only the family of Nanlal Saha were included in the plaintiff. He has submitted that in absence of Parmeshwar Saha and Ishwari Saha, the suit for partition was not maintainable, and therefore the suit was fit to be dismissed on account of non-joinder of necessary parties, or the learned trial court ought to have exercised power under Order 1, Rule 9 and 10 for addition of parties. The learned counsel has referred to the plaint and has submitted that the genealogy which has been annexed with the plaint itself in paragraph 11 is not in dispute. He has in particular referred to paragraph 8 and 9 of the plaint and has submitted that it has been categorically stated therein that Schedule A property was still joint property of the plaintiffs and the defendants, and that the defendant number 1 and 2 and there has been defendant number 1 and 2 were enjoying the major portion, and plaintiff number 1 and 2 were living on the same property, correct?
Yes, sir.
And defendant number 3 to 6, 3 to 5 ऊपर लिखा है, 3 to 6 होगा, 3 to 6 used to enjoy the property whenever they used to come from the sasural. This is on point of non-joinder of necessity.
One more thing I would like to add, Your Lordship. This fact is supported by the learned court below itself in the decree at page number 36 of my appeal, the decree portion, paragraph number 28. The learned court below have himself recorded that at paragraph number 28 of the decree that there is no document on record in support that there was partition among Nanlal Saha, Parmeshwar Saha and Ishwari Saha. So
the learned counsel has submitted that in paragraph number
28 of the decree.
Of the trial court judgment, the learned court has themselves recorded that there is no document on record to support that there was partition amongst Nanlal Saha, Parmeshwar Saha and Ishwari Saha. But the plaintiffs in their evidence, that much is your submission.
Mayor, on the basis of preponderance of probability, he has, the learned court below has decided this issue in favor of the plaintiff without going into the oral or documentary evidence.
Nearly on the by applying the principle of preponderance of probability, this issue has been decided in favor of the plaintiff and against the defendants. against the defendant number 1 and 2.
1 and
He has submitted that so far as defendant number 3 to 6 are concerned. 3 sisters say? 3 to 6 or 3 to 5?
3 to 6.
3 to 6 are concerned. They had fully supported the plaintiffs. This is on non-joinder.
This is on non-joinder of necessary party.
What is about issue number 4?
Your Lordship would come to issue number 4. Issue number 4 was with regard to whether the entire land of the ancestral property are included in the suit or not. The learned court below has decided this issue in favor of the plaintiffs.
इसमें से exhibit A निकालिए. Yes.
Even when the defendants have categorically stated in their written statement that other ancestral property which belong to the great grandfather of the plaintiff number 2 has not been included in this particular claim. I'll show it from the written statement itself.
Is there any averment in the plaint with regard to other properties?
No, Your Lordship, they have not awarded.
Okay, what is there in the written statement?
The written statement of defendant number 1 and 2.
Okay.
Paragraph number 11.
Para 11.
That the land of Khata number 22530, plot number 5841/6337, area 1 acre, and land of Khata number 220/515, plot number 5841/6471, area 1.05 acres are of village Gomo, PS number 12, PS Telaiya, district Hazaribagh, Mahakotrama, was acquired by Punitra, great grandfather or Pardaza of defendant. The genealogy table they are shown.
Power of attorney. Registered power.
The above said land where are in joint possession of the legal heirs of Punitra, and no partition was done by meets and bond in between the legal heirs of Punitra. In the acquired said land, some portion was sold jointly to the two different purchasers. So therefore, specific plea was taken by the defendant number 1 and 2, the appellants herein before your lordship, that other ancestral property which belonged to the great grandfather of plaintiff and the defendant was not taken into consideration in this particular suit by the plaintiff, and it is held by the principles of order 2 rule 2, your lordship, that the whole claim should be included in the suit, so that there should not be any multiplicity of litigation.
The counsel for the appellant, while referring to issue number 4, has submitted that, has referred to paragraph 11 of the written statement, and has submitted that clear description of the other property was given in the plaint, which stood recorded in the name of great grandfather of the plaintiffs and the defendants, namely Punitra, and it was also mentioned that there has never been any partition done with respect to the said property by meets and bond. He submits that the said property was also required to be included, and in absence of which the suit was hit by order 2 rule 2 of CPC. He has submitted that partial partition with respect to the property is with respect, partial partition with respect to only a portion of the entire joint family was not permissible under law. We have submitted that however, during the course of hearing, he has submitted that the plaintiffs had not disclosed any property other than the suit property in their plaint.
Neither they have shown any documentary or oral evidence. They have laid down any documentary or oral evidence in during the course of trial, the lordship, with regard that this particular scheduled A property which they are claiming to be partitioned by way of partition suit, that has been devolved by way of partition among the descendants of Punitra.
ये तो non-joinder में आ जाएगा. The learned counsel has also submitted that the plaintiff has not produced any documentary evidence to show that the suit property devolved exclusively in the name of Nandlal Lal, son of Punit Lal.
He would be, yes, son of Punitra.
Right? Continue please.
And the learned court below has decided this particular issue, holding that even after specific pleading was taken in para 11 of RWS, but he has not considered this specific pleading, rather only on the basis of the avowment made by the plaintiffs that the partition has been done. Only this much has been written without adducing any documentary or oral evidence. He has considered this issue in favor of the plaintiff. Therefore, it is wrong, because Order 2 Rule 2 states that whole claim should be added in any suit, so that there should not be any multiplicity of litigation amongst the necessary parties in any suit, in partition suit.
The learned counsel has submitted that the learned trial court has wrongly इसके बारे में तो पार्टीशन में नहीं बोला. इसके बारे में तो ये बोल, they have said that it was sold and how much property was left has not been mentioned. It was sold by virtue of Exhibit A, but it has not been mentioned as to how much was left.
Even then, he should have not decided this favor in favor of the plaintiff, because if it is not sure that how much portion has been sold or how much portion has been left, so therefore
it was for you to say, no? You produce Exhibit A,
yes,
power of attorney. Then you should have said that this much was the remaining property which was yet to be partitioned. If the property, who was the seller of that? Who was the seller of that property?
The descendants of Punitra.
Okay.
So
Descendants of.
I was also one of the descendants, Nannat Saha.
Did you join in the power of attorney also? You said it.
No.
So Puneet, this other brothers of Nandlal had sold this property without any objection from anybody.
Yes, sir.
So this particular property.
Even then, this fact has come before the court that some of the portions are still left.
Now, which portion was left?
That could
What
not
was
be
the
asserted.
total area? What was the property left to be sold?
That was not.
And this
categorically asserted.
sale was never challenged
Yes, sir.
by anybody.
No.
You never objected to this sale. That this is a joint family property, did you?
No, at that time I have not objected to this when that particular property was being sold by the other
You
descendant.
never objected to that.
But we
Do
had
you-
brought
do
to
you
the
get-
notice of the court.
As
That there
a
are-
litigant and as a counsel to the litigant,
Yes,
do you get it that if you say that this property, suit property, is a joint family property, then all extended family will get a share in this? Do you get this?
yes, sir.
What is the benefit you are getting out of this? You see, you have a house consisting of 10 rooms. As per the plaint, there are 10 co-sharers and each one gets one room. Now you say that no, it is a joint family property of extended family. So now another 20 people will come and say that they are the owners of this property. So how much will you get ultimately? You will get 1/4 of a room. Not even one room. So are you really serious about the litigation? You are unnecessarily, as a litigant I am telling you, you are unnecessarily calling upon more shares in the property.
So, Lordship, out of the report, I had a talk with the client himself. I have told that as per the Supreme Court judgment, the females are entitled.
They are entitled.
They are entitled, but he has instructed me to press this appeal, therefore, Your Lordship. Otherwise, I have suggested him that this.
This is, isn't it? It is against him.
Yes, Your Lordship.
Is it there in the court? No.
No. I have suggested him that let this decree should be executed because already a execution case is pending. Otherwise, all the parties
Yes.
would be added in the suit and you would get nothing
You will
out
get
of it.
nothing out of it.
I had informed about it, but he was not ready. Therefore, I was.
Would you like to go for a mediation?
They can.
I don't know.
If he is ready, then they can. They can like
आप
settle
समझ रहे हैं
settle
ना?
it down. Yes, sir.
आपके इस प्रॉपर्टी में 20
सब आ
शेयर आ जाएंगे.
उससे भी ज़्यादा है Lordship.
You go and talk to your client. If you insist, there is no problem. I've heard so much. Even I was wondering as to why have you filed this appeal. You are inviting extended family members to join in and as co-sharers.
I'll take
You
this,
go
sir.
and talk to your client,
Yes, sir.
right? If he is serious about, there are two options. Either he may simpliciter withdraw it on instructions because females का तो property का right है. इसमें it is absolutely settled. There is no doubt.
Yes, sir. I have read this.
And whether he wants other co-sharers, so-called co-sharers, to come in and litigate in this matter, you just seek instructions
Yes, sir.
and come in 15 minutes.
Yes.
Right? Otherwise, we will decide it here and now. There is no problem about it.
Yes, sir.
I was just wondering as to why is he putting problem for himself. Go and ask him.
Yes.
Special median practice item 4, second appeal 100 of 2019.
Yes, can it be sent for mediation?
It may be simple.
Yes, sir. At the instance of the learned counsel for the appellant, let this matter be placed for ongoing mediation.
From tail case to be mentioned case item 1, second appeal 42 of 2023.
देखिए second appeal number 42 of 2023. This matter was disposed of. The second appeal was dismissed by judgment dated 22nd April 2025. However, the matter was placed before this court at the instance of the office, stating that the case number that on perusal of case record, the case number has been mentioned in the trial court's judgment as title suit number 76 of 2001 and also title suit number 76 of 2013. Further, case number in the trial court's decree has been mentioned as title suit number 76 of 2013. The trial court's judgment was sent back for necessary correction, and the learned trial court has passed an order dated verified and reported that the correct case number is title suit number 76 of 2013. It was duly verified by from the records, and it was submitted that the typographical mistake was already corrected on 9/1/2020. In view of the aforesaid, the title suit number 76 of 2001 mentioned in various places in order dated 22nd April 2025 is directed to be read as title suit number 76 of 2013. Office to carry out necessary corrections. एक ही जगह मेंशन पैराग्राफ में से और तो कहीं नहीं दिखा.
For final disclosure, item 2, second appeal 328 of 2016.
Where is the appellant? स्टेट में तो है लेकिन ये तो स्टेट का केस नहीं है।
नहीं
The learned counsel for the appellant is absent. Yes, are you there in this case?
Good. Next.
इसका किसका नाम है आपके? Nobody appears on behalf of the appellant. Counsel for the respondent is present. Earlier also the case was adjourned at the instance of the appellant on 6/5/2025. Are you there in this case?
So that I can submit.
There is. Either you text him and you start that.
Let's just one piece. I will.
Item 3, second appeal 734 of 2016.
Yes. Appellant.
And the original plaintiff legal of the plaintiff. The suit was title suit was decided in my favor, and the appeal was decided against me. Therefore, I got the second appeal. But the original plaint was filed under section 11 A, C, D, and E of the Jharkhand Building
Just
Control Act.
Under section 11
A,
A,
C,
C,
D,
D,
E of Jharkhand Building Rent Eviction Control Act 2000. But my case was
it is admitted.
yes, admitted my lord by order dated 22/4/2019. Substantial portion of has been claimed order. But very short facts I will that the issue was filed in the year 2002. The lease agreement was dated September 1996. It was valid for a period of 5 years between the plaintiff and the original defendants. Original plaintiff, original defendant. And rent was fixed at the time 500 per member. And they
Just a
have
moment. original plaintiff, there was only one plaintiff and one defendant.
Yes, sir.
Lease agreement is dated
My lord, September 1996.
September 1996 for a period of
5 years?
5 years. Registered?
No.
Not
It
registered.
has also not been brought on record.
Not registered, not brought on record.
No. And rent was fixed at 500 per month.
Rent at the rate of 500 per month.
And the defendant has given the advance of rupees 30,000.
Defendant. Advance of rupees
30,000.
When did the period this
My lord,
Adjusted.
April 2001 they have stopped paying rent. From May 2001. The agreement was till April 2001.
when
And,
did this 30,000 got consumed?
my lord, from May 2001 they have stopped paying the rent. We have not stated anything because that 30,000 was also to be there. My lord. Then 2001 August, my lord, we have allowed the defendants to continue the premises, adjusting the remaining advance amount of rupees 30,000. August 2001, and
It was adjusted later on.
not
30,000
May
you got it
2001.
adjusted.
May 2001 they have stopped the payment of rent.
Okay.
In August 2001, the agreement was for 5 years from 1996 September to August 2001. From August 2001, we have allowed them to continue, the defendants, we have allowed them to continue for adjusting the advance amount of 30,000. And on 1st of September 2002, we have requested the defendants to hand over the possession of the suit premises.
On account of personal necessity.
On 3 account note, expiry of lease, personal necessity, and the rent also. The rent was not paid.
Yes. Personal necessity, default. Okay. Then
3 grounds. And my lord, in November 2002, we have filed the suit under section 11(1) A, C, D, E, and F.
what are
C-
these? A is default.
A is my lord breach of condition of tenancy.
Okay, breach of condition of
Because we are
tenancy.
claiming that they have structured some portions over there. my lord.
Okay. Breach of condition of tenancy.
C is bona fide requirement.
Bona fide requirement.
D is default.
Default.
E is expiry of tenancy.
There is only one question of law.
My lord,
Whether legal heirs of landlord can be treated as
yes, my lord,
landlord.
because
in
that is
necessity
important.
of
my lord.
circumstances.
My lord, the suit was filed in the year 2002. The original plaintiff died in the year on 4/6/2012 during pendency of the suit.
Okay.
And in the plaint, my lord, for bona fide requirement, in the plaint, my lord, it is stated that the present applicant's husband will look after all the businessmen. In the plaint, it was stated. Therefore, my lord, bona fide requirement was pleaded in the petition in the plaint.
No, I don't get
And in
it.
the
I don't get it. Whose bona fide
my lord,
requirement?
the bona fide
The
requirement
requirement of the
husband of the applicant at present applicant's husband.
Okay. Appellant's husband.
Applicant's husband, my lord. The
And
applicant is
appellant died.
plaintiff died. Original plaintiff died in the suit.
Okay. Plaintiff was the wife or the husband?
My lord, he was the owner and
आप तो पूछे रुक जाइए
my lord, he was male, my lord, and
he was the husband.
no, the present applicant. She has
You
filed.
just tell us who was the original plaintiff.
My lord,
नाम बताइए.
Govardhan Das Lachiramka.
Govardhan Das. Right?
Das Lachiramka.
Okay. Who died?
My lord, he has died.
When?
My lord,
4/6/2012.
substituted is Kusum Devi, wife of
substituted by Kusum
Kusum
Devi.
Devi, wife of Arun Kumar Lachiramka.
Kusum Devi. How is she related?
No, I'm saying Arun Kumar Lachimarka is the bhatija of original plaintiff.
Nephew.
Nephew.
Wife of nephew.
Wife of nephew.
How wife of nephew has
Lord, in
been
the plate, my lord, he has stated that he has no legal heirs, and Arun Kumar Lachimarka and his wife Kusum Devi will are looking after the household affairs and taking care of me. Therefore, my lord, the will was also made in the name of Kusum Devi in the year 2004 itself, 15/3/2004. And in the plate, it was specifically mentioned that this business will be bona fide requirement is for Arun Kumar Lachiramka and his family. Therefore, my lord, in the suit, when the original plaintiff died, so Kusum Devi has filed the substitution petition. Why she has filed, my lord? Because in the year 2004, the will was made by original plaintiff in the name of Kusum Devi. Therefore, she has filed the substitution petition, which was allowed. But due to technical error or negligence, my lord, her name was, the order is there that she has been substituted because no other legal heirs of Govardhan Lal Lachiramka has ever filed a substitution petition claiming to be their legal heir. Order is there in the title suit, but due to some error, my lord, his name was not struck off, and the name was recorded as Gopal Das Lachiramka. And the
by which order she was substituted? Order dated?
My lord,
15/4/2014.
15/4/2014
In the suit.
in the suit.
This was never challenged.
No, this was never challenged.
But the order was not carried out.
But the order was not carried out.
Now come to the question of
Yes.
law stricter.
Lord,
Why should we bother
the
about
learned
all
appellate
these
court,
things?
my lord. The learned appellate court has stated in short, I am saying that the learned appellate court has, while rejecting my case, has stated that I am not the landlord, original landlord. I have no concern, my lord. Therefore, my lord, the suit property cannot be given to me.
No, whether the legal heirs of landlord can be treated as landlord,
Yes,
claiming necessity of suit property after the death of original landlord.
Here, my lord, two questions will arise. First, at that time, the probate of will was pending.
That will not arise because substitution was already
Substitution
allowed.
was done, and the Supreme Court judgment, my lord, Honorable Apex Court judgment is there that it will always be resulting to the final judgment of the probate case. That probate case was not decided against me.
It was decided against
Yes,
you.
sir. That is challenged before this Honorable Court and miscellaneous appeal, my lord, that is still pending. The miscellaneous appeal number is 194/2024. 194 of 2024.
It's the status.
And the probate case number is 1 of 2012. The judgment is dated 20th March 2024. MA 194/24.
ये रहा जो judgment probate का.
So my first submission that would be that by relying on the Honorable Apex Court judgment.
Which judgment?
ये probate
नहीं, ये तो probate का होगा.
Which judgment?
Yes.
फिर उस एक मिनट में हम लोग को एक चीज बोलने दिया जाता है because within the meaning of section 100 and clause 5 of CPC which says that at the hearing it is the right, it would be the right of the defendant to plead that the substantial question does not involve in the present case. So it would अगर इधर सुना जाता और फिर हम इस चीज को प्लीड करते थे my lord may say that why you have wasted the time of the court not.
आप मेरे टाइम की चिंता मत कीजिए, हमको जरा समझने दीजिए उनका केस. आपको बिना सुने थोड़ी ऑर्डर कर देंगे.
नहीं हम खाली मेरा वो है कि ये सब्सटेंशियल क्वेश्चन ऑफ लॉ इन्वॉल्व नहीं.
आप बस कुछ मत बोलिएगा, हमको जरा हमको सुनने दीजिए.
Let me
Yes.
kindly see para number from 8 number.
Yes.
It is this order of the Honorable Court that was challenged by the appellate in this court by your specially petition, which on grant of leave was heard in the presence of the learned counsel of parties. During the pendency of this appeal in this court, no question has been on this matter. Our original tenant responding but to hearing has expired and its heirs and legal representatives to brought in court. Before us, the only question that has to be gone into is whether the appellant on the death of the original plaintiff, namely Jharkhand Lal, was entitled to be included, substituted in the suit for eviction along with the natural heirs and legal representatives of the deceased, namely also learned senior counsel appearing on behalf of the appellant submitted that since a separate probate proceeding has already been instituted by the appellant for grant of probate in the completed court of law which is now pending, the only course open to the court was to substitute or include the appellant in this eviction proceeding along with the natural heirs and legal representatives of the deceased plaintiff. That is to say, the entire proceeding should be carried out not only by the natural heirs and legal representatives of the deceased plaintiff, but also by the appellant, subject to the grant of probate by the court of law. In the support of this contention, so appearing on behalf of the appellant has drawn our attention to a decision of this court in so. Let me kindly see para 15, para 14. Having heard the learned counsel for the parties and after going through the medium order as well as the application for substitution of the appellant on the basis of the bill alleged to have been executed that the deceased plaintiff, we are of the view that the entry of the High Court is liable to be interpreted and the application for implement filed at the instance of the appellant on the basis of the bill alleged to have been executed by the deceased plaintiff must be allowed and the appellant must be included in the suit along with the natural heirs and legal representatives of the deceased plaintiff, subject to grant of probate by a court of law.
Here the natural here has not been included.
No, he has not been included.
So
I was claiming on the basis of bill.
that's
And the situation at present is that the probate
at
case
present का नहीं चलेगा ना.
नहीं तो probate case मेरे favor में decide नहीं हुआ. But we have challenged that in.
That's right.
That
is a
still
separate thing.
That
Whether
is-
the legal here of landlord can be treated as
So the
landlord.
learned appellate court has only gone that I am not the landlord. If may not be see the order judgment of the learned appellate court.
defective.
Let me kindly see para 13, internal page 13 of the appellate court judgment. Para 13.
Yes, I'm there.
In the light of the oral as well as documentary evidence brought on record as discussed above, I wish to answer the questions formulated above the whether death of sole plaintiff, Kusum Devi, daughter-in-law of the nephew of the deceased plaintiff, can be treated as landlord with the meaning of section 2 read with section 11(1) explanation 1 and thereby the relationship of landlord and tenant continues between the plaintiff and Kusum Devi could contest on behalf of the deceased plaintiff. The term landlord has been defined under section 2 which says that landlord includes the person who for the time being is receiving or is entitled to receive the rent of the building whether on his own account or on behalf of not her or on account or on behalf of the benefit of himself and others as an agent, trustee, executor, administrator, receiver, guardian or whom is to receive rent or be entitled to receive the rent if the building was let to a tenant. Section 11(1) expansion restricted the meaning word landlord and excluded an agent referred to in clause F of section 2. In the present case, the suit was filed by the suit plaintiff, but during the pendency of the suit, he died on 4th June 2012, and on 7/7/12, a petition was filed by Kusum Devi informing the death of sole plaintiff and praying for substitution. This case on the ground that deceased Govindas Lachithanka died leaving behind Kusum Devi, his daughter-in-law, of the nephew through a will. And
The bill was only in favor of Kusum Devi.
yes,
आगे
and I further find that learned lower court pleased to allow the same by order dated 15/4/2014, but surprisingly, name of the Kusum Devi was not incorporated in the body of the bill in place of deceased plaintiff, and as such, decree was passed in favor of deceased plaintiff Govindas Lachithanka. It is true that a decree in favor of the dead person is nullity, but in a suit where the right to sue service legal or legal representative can very well maintain the suit in absence of the deceased plaintiff. In this case, there is no dispute that there was a relationship of landlord and tenant between the deceased plaintiff and defendant. but the relationship comes to an end on the death of Govindas Vechinaka unless a legal representative is brought on record. Kusum Devi has claimed that she is daughter of the deceased plaintiff, and as such she cannot be treated as the legal heir of the deceased plaintiff, and even if a will is left in her favor by the deceased plaintiff, same cannot take effect. The same is duly probated in the court of law. There is nothing on the record to show that Kusum Devi was declared legal heir as a complainant. In a similar circumstances, before Honorable Supreme Court in the case of Tenancy, it was held that the legislature was restricting the meaning of the expression landlord for the purpose of 11(1)(c), manifested its intention only that landlord alone can sue for eviction on the ground of his personal requirement if he is one who has a right against the whole world to occupy the building himself, and exclude anyone holding that title lesser than his own. Such landlord who is an owner and who would have a right to occupy the building in his own right can seek possession for his own use. A rent collector or an agent is not entitled to occupy the house in his own right, even if such a person be a lesser.
This person had no children.
In the plaintiff it is stated.
In the probate case, who had challenged the probate?
And the other legal heirs, some brother of the plaintiffs and their children's payment, because I was not knowing about the probate case details.
Who had challenged the bill?
वो भतीजा लोग जो बाकी भतीजा लोग था, बाकी 3 भाई का बेटा लोग, they have been made parties by the Kusum Devi
See,
itself.
the natural heir is not a party.
Yes, natural heir
नहीं
but
चलेगा ना.
एक चीज-
Natural heir को तो party बनाना, including her husband could have been a party.
Yes, he was not.
Her husband also was not made party.
why will not, because the bill was made in the
Maybe bill is a chit of paper till probated.
इसमें मुझे एक चीज खाली
और link में भी बना
इसमें
लिखा है.
सब्स्टिट्यूशन हुआ है, इसका लास्ट पैरा का देखिए, इनको
Like-
सिर्फ और सिर्फ जो है खाली लास्ट पैरा सब्स्टिट्यूशन एप्लीकेशन पर ये लोग बोले कि चैलेंज नहीं किया, हाँ चैलेंज नहीं, बल्कि इनको चैलेंज करना था हमको, ये वो लास्ट पैरा देखिए, उनको सिर्फ और सिर्फ लिमिटेड दिया, इट वाज नॉट सेड दैट शी हैज बीन एडेड एज अ हियर इन द सब्स्टिट्यूशन एप्लीकेशन इटसेल्फ, which she has not been added, और ट्रायल कोर्ट को कंफ्यूजन
Kusum Devi is directed to be substituted in place of the bill.
ओनली फॉर लिमिटेड पर्पस योर लॉर्डशिप, उनको भाड़ा भी नहीं देने दिया है, लिखा है हमको कोर्ट में जमा किया और आज तक हम जमा करते आए हैं अप टू डेट, और शी हैज क्लेमिंग टू बी द लीगल हेयर ऑन द बेसिस ऑफ अ विल, therefore she has excluded the other legal heirs, she has not been made party and we have objected. For contesting the suit, not as a legal heir.
Contesting the suit so that the suit may not abate.
But कहीं पे भी determination नहीं हुआ legal heir का कुछ भी, and लोग जो वो
नहीं unless the
और वो खुद भी जो प्लेंट जो प्रोबेट फाइल की उसमें अदर लीगल हेयर्स को पार्टी बना, इसमें दो चीज बहुत इंपॉर्टेंट हुई. एक बार हिंदू सक्सेशन एक्ट का ये देखा जाए जहाँ पे लीगल हेयर्स का है कि who will be legal heirs, she is not at all legal heirs within the meaning of Hindu succession act. Property can be called by two, a intestate successor or by the testamentary successor. So intestate successor में उनको या तो legal heir होना पड़ेगा, class 1 और class 2. She is not a class 1 here, she is not a class 2 here. So question of heirship is gone. और अगर testamentary succession में जाना पड़ेगा तो will has to be probated. Will has not been probated, rather it was dismissed. तो जो पहला substantial question of का आंसर करने के लिए she must be a legal heir, because the question is that whether a legal heir can be treated as a landlord or not. So the first one has to be a legal heir. तो एक बार इसको class 1 heir and class 2 में भी see
only for
अगर
5 years.
अरुण कुमार लच्छीराम का पार्टी.
My lord, the definition of landlord, it doesn't state that only legal heirs can be substituted. The landlord includes other malord. And
Other
if malord
things.
may kindly see para 15 of the plaint, original plaint malord. In the plaint itself, it is stated that the plaintiff submits that after the death of the wife of the plaintiff, his bhatija Arun Kumar Lachiranga and his wife Kusum Devi are looking after the household affairs of this plaintiff, including his business affairs, and practically as Arun Kumar
No,
Lakshmi
that will
Mata
not
is-
be,
and,
that is not sufficient.
my lord,
If Arun Kumar Lachinanka was there, I would have no case.
my
I'm
second,
admitting.
second argument,
She is not the legal heir.
my lord, my second argument, my lord. Second argument, if tomorrow the MA is decided in my favor, in a miscellaneous appeal, then
Then
the
you will
property,
be, then under such circumstances,
then we have to again file for the eviction, my lord. The agreement has also been expired. The tenancy agreement is also expired, my lord. It was for the 5 years, from 2001, my lord.
substitution has been wrongly carried out.
My lord, from 25 years, the defendant is illegally occupying.
I'm paying the rents before the court concern.
No proof has been
हम अभी
attached.
नहीं देते।
No proof
I'm
is
paying
there.
my statement और हम इसमें दिए हैं
They have to file.
उसी जजमेंट में उसी सब्स्टिट्यूशन पिटीशन में इन्होंने हमको अलाउ किया रेंट देने के लिए जो अभी हम 14/5 का जो ऑर्डर दिए और हम दे रहे हैं।
They have to file a case before HRA, House Rent Controller.
तो ये जो question of law है, this question of law does not arise here.
But
Just justify this question of law which has been framed at your instance. Whether the legal heirs of landlord can be treated as landlord. You are not the legal heir.
the only condition, the appellant, Kusum Devi, in the claim, it was also written that she is looking after the affairs for the original plaintiff, and the bill was also made. That bill was dismissed, probate case was dismissed, MA was filed, that is pending. Tomorrow, whether the suit was case is decided in my favor, then I have to again file for eviction. But it can always be to subject of the final result of the MA. The lease, the tenancy lease has also expired, and the bona fide requirement is in my favor.
MA में क्या हो?
MA pending है, मतलब admit हो गया है, notice हुआ है, अभी pending है.
आप appeal कर गए हैं? आप पार्टी नहीं है?
पार्टी
आप तो नहीं
है,
होंगे?
पार्टी है.
ये भी पार्टी है?
नहीं हाँ
थोड़ी
तो
होगी
नहीं
पार्टी.
ये पार्टी नहीं जो भतीजा है, बाकी लोग जो है वो है. और second question, my lord has earlier asked whether the bona fide requirement comes to an end, my lord. After the death of the original plaintiff, my lord, I have given 3 judgments, my lord. It cannot come to an end, my lord.
Essay number 334 of 2016. For the learned counsels appearing on behalf of the parties. The suit was decreed in favor of the landlord on numerous grounds, including it was decreed.
Yes, my lord. Decreed in the landlord's favor, my lord.
Was decreed in नहीं ऐसा The learned counsel for the appellant has submitted that the suit was filed for eviction under section 11 within bracket A, within bracket C, within bracket D and within bracket E of Jharkhand Building Control Act. The landlord expired during the pendency of the suit. On 4/6/2012. The suit का number लिखेंगे, title suit, title within bracket eviction bracket 2 suit number 4 of 2012. And a petition for substitution was filed by daughter-in-law, by the wife of his nephew, namely Kusum Devi. Primarily on the ground that a will was executed in her favor on 15/3/2004. However, the natural heirs and successors were not made, did not file any substitution. The learned counsel has submitted that the substitution was allowed by the order dated 15/4/2014, but unfortunately the substitution was not carried out, and the appellate court considered the entire aspect of the matter and held that the relationship of landlord and tenant came to an end on the death of the original landlord, namely Govindas Lachiramka, unless his legal heirs or legal representatives is brought on record. And that she cannot be treated as a legal heir or legal representative. And will not take its effect till it is probated by a competent court. And there was nothing on record to show that Kusum Devi was declared legal heir by a competent court. The learned counsel has submitted that the probate case has been dismissed in probate case number 1 of 2012, and an appeal being miscellaneous appeal number 194 of 2024 is pending, which has been admitted and notice has been issued. He has submitted that the suit was decreed and the first appellate court has reversed the decree. So far as the present case is concerned. And consequently, Kusum Devi is the appellant before this court. He has submitted that if this appeal is dismissed at this stage on the ground that Kusum Devi is not the legal heir and successor, then after the decision in miscellaneous appeal, she would stand on the legs of the original landlord, and therefore this appeal be kept pending, or the appeal itself be tagged with MA number 194 of 2020. Considering the aforesaid submissions, let this appeal be listed after disposal of MA number 194 of 2024 or on last January, whichever is earlier. क्या हुआ?
Lordship, I have taken the instruction. They are ready to go to mediation. The Lordship, I have told them that they can sit with the defendants because some rooms are occupied by these defendants, so they can decide which all rooms.
समझ में आ रहा है उनको बात?
I have told. That
समझ
is,
में आया कि नहीं? आपने तो बता दिया.
हाँ समझ गया कि अभी 8 ही लोग ना होना है, नहीं तो 20 या 30 भी हो सकता है।
बीस भी हो सकता है। उसके बाद एक एक कोना पकड़नी चलेगी। ठीक है, वी हैव स्पेंड सम टाइम बट स्टिल अगर मीडिएशन हो सकता है
नेक्स्ट सैटरडे दे आर विलिंग टू कम टू
डालसा फॉर मीडिएशन
यस
आपको भेज दें?
भेज दीजिए, लेकिन नेक्स्ट सैटरडे पॉसिबल नहीं।
अरे ऑनलाइन ज्वाइन करा दीजिएगा। ऐसा पॉसिबल नहीं है क्यों बोलते हैं? सब चीज पॉसिबल है। ऑनलाइन ज्वाइन करा देंगे, भाई बहन है सब। मदर इज अलाइव,
नो
सब्स्टिट्यूट होगा
मदर वाज प्लेंटिफ नंबर 1 शी डाइड
तो डिलीट हो गया ना?
यस
शी हैज बीन डिलीटेड।
यस यस
ऐसा ना तो बोलना ही नहीं है मीडिएशन। हाँ? पार्टी को बोलिए, समझाइए। जब आप एक बात बताइए, मीडिएशन में क्या होगा?
तो ऑनलाइन में फिर
पार्टीशन किया है तो मीट्स एंड बाउंड से ही तो सब कुछ करेंगे।
यस
तो आपस में बंटवारा करके कर लीजिए। क्या है इसमें होने वाला?
सीट ऑफर रेडी पर लिंक तो भेजना पड़ेगा दोबारा।
हाँ, वो सब चला जाएगा, उसका आप चिंता मत करिए। ठीक है, आप एक बार उस दिन नहीं भी हो पाएगा तो नेक्स्ट डेट में होगा, वहाँ तो टाइम ले लेंगे। ठीक है, देखिए एफए नंबर, एफए है ये,
यस सर
एफए नंबर 201 of 2015 with the consent of the learned counsel for the parties, this matter is referred for mediation to Jhalsa. The counsel for the appellant has submitted that the matter may be fixed for mediation on next Saturday. Counsel for the respondents has submitted that he shall try that the respondents may also join on the same date. However, the parties are directed to appear. Since the parties are requesting for mediation, let this matter be placed before the Secretary Jhalsa for mediation, and initially the date for mediation be fixed on Saturday at 11 a.m.
One more thing, Your Lordship, since execution is pending, they should not proceed, otherwise they would press.
Stay नहीं करेंगे।
Stay, I am not for stay, Your Lordship. ये
ऐसा
अपना
नहीं, इस तरह से नहीं हो सकता। मीडिएशन करना है तो आप अपने भाई बहन को मनाइए। नहीं, ऐसा करते हैं ना, पार्टीज टू नेक्स्ट सैटरडे हो जाएगा।
नहीं, आज तो थर्सडे होंगे।
नेक्स्ट सैटरडे, Your Lordship.
नेक्स्ट
August.
सैटरडे कंसेंट करते हैं आपका?
हाँ, ये सी।
ठीक है, with the consent of the parties, let this matter be posted, be referred to mediation in Jhalsa.
Second.
The parties have agreed to appear before the Secretary Jhalsa on next Saturday at 11 a.m.
Yeah.
Right? Post on September 8th, awaiting mediation. आपका तो अपील ही देख के हम कंफ्यूज हो गए, क्यों ही लड़ रहे हैं लोग।
Lordship, I had told them initially that it is a waste of time, but they were adamant that you should press
उन लोगों को नहीं पता ना, हिंदू वुमेन्स राइट टू प्रॉपर्टी के बारे में नहीं। गॉट इट मैडम? समझ में आई बात? नहीं आई? एक पासवर्ड
Password from supplementary list item Q, second appeal 274 of 2023.
सॉरी मैडम, वेरी सॉरी।
बताइए।
एक बार कल से आज लाए, फिर आज पास हो गए। तैयार है मुझे, लेकिन प्रॉब्लम क्या है? बहुत परेशान से।
ये प्रॉब्लम
Now your lordship, this is the plaintiff's
आपको
first.
पता है, सबको हम कॉस्ट करते हैं, अब आपको नहीं करेंगे तो बहुत
ना, हम तो जो रेडी हैं, हम ऐसा नहीं कि भागेंगे। हम तो जो सिर्फ समय मिल गया उसके लिए हम वेरी मच हो रहे हैं। कम से कम 2 घंटा समय हमको मिला। इस बीच में तो 227-28 केस तो अटेंड किए। इस बीच में सिर्फ 2 घंटा का और उधर हम फ्री है, कोई प्रॉब्लम नहीं.
आपको बस
Now it is a very short case. I lost in both the courts. This is third round litigation for me. Plaintiff filed a suit for three declarations. Number one, first of all, the declaration that the Parcha granted under the Bihar Privileged Person Homestead Tenancy Act in favor of the defendant number 1 or defendant number 4 is not valid document, and the circle officer had no authority to issue such Parcha. This is first. Second declaration.
नहीं, ऐसा नहीं. You say that it is forged and fabricated.
Forged and fabricated, that and he has no.
सर्कल ऑफिसर का अथॉरिटी का कहानी हमको कहीं दिखा नहीं है.
नहीं, रिलीफ में देखा जाए.
दिखाई?
रिलीफ जो मांगे हैं, ट्रायल कोर्ट का जजमेंट में
पढ़िए,
रिलीफ
पढ़िए.
कोर्ट किए हैं. ट्रायल कोर्ट का जजमेंट भी जो देखा जाए.
हाँ नहीं, ये तो डिक्री में देख रहे हैं जो आप लास्ट में लगाए हैं. लास्ट
डिग्री जो ट्रायल कोर्ट का डिग्री है, उसी में जो देखा जाए. और ऐसे पैरा 2 में भी है, पैरा 1 में डिग्री मौजूद देखा जाए. ये
एंटीडेटेड बोले हैं.
इंटीग्रेटेड और भी jurisdiction के बारे में.
Jurisdiction का पॉइंट आप नहीं लिए.
ट्रायल कोर्ट का जजमेंट डिग्री देखना है कि अपीलेट कोर्ट का, दैट इज अपीलेट कोर्ट जजमेंट.
आप अपना रिलीफ से दिखाएंगे.
और रिलीफ पैरा 1,
पैरावानी तो हम देख रहे हैं डिग्री से.
yes, page 53 of the trial court judgment.
अच्छा, ठीक है.
It has been extensively quoted. Para 1, page 53.
Page 53 of trial court judgment.
Yes, para 1. The plaintiff has instituted the instant suit for the
आपका
following reliefs.
पेज नंबर टैली नहीं कर.
Trial court judgment का first.
हाँ.
It be adjudged and declared that the Anchal Adhikari Hiranpur never issued any patta BPPHT Act to defendant number 1's husband or our favor defendant number 4, nor he could issue any patta under BPPHT Act for the land of the suit property, and the alleged patta under BPPHT Act is an antedated and forged paper which did not confer any right or title to the dependents upon the suit premises, nor the same is binding upon the plaintiff. Second relief, plaintiff declared that the plaintiff has got her subsisting right title to an interest in the suit properties, and the possession of the dependents over the house of the suit properties is illegal since January 2000. And the claim of right title and possession of the dependents over
What is the finding with regard
now
to?
I'm coming to that. These are the relief short for. Now your Lordship may kindly come to only in 2 minutes and I will just narrate the facts in short.
हम पढ़ लिए सर आप.
5/1/1938
आप मुद्दा पे आइए. आप
मुद्दा
बताइए.
में ट्रायल कोर्ट जजमेंट का जो पैरा 4 निकला. पैरा 4 are the issues. Then Milord, issue number 6, 7, 8 and 9 are the 4 issues which are important. Issue number 6 is relationship of landlord and tenant. Issue number 7 is default. Issue number 8 is title. Issue number 9 relates to basket purchase. That is dated 11th February 1975. Now your Lordship may kindly see the page 14 of the trial court judgment, which are the documents relied on. In cursorily, Exhibit 1 is the receipt, Exhibit 2 is the sale deed dated 5/1/1938, Paramount title holder. Exhibit 3 is Khatiyar. Exhibit 4 is sale deed of the plaintiff, 22/5/1974. Exhibit 5 is the so-called filed by them in 144 proceeding. Exhibit 6 series are the rent receipts in favor of the plaintiff. Now your Lordship, directly come to page 109. Page 109. Issue number 6, 7 and 9. 109.
आपका नंबर बिल्कुल टैली नहीं करता है.
So
इंटरनल
it
पेज.
starts from internal page
इंटरनल
57.
पेज 57.
57.
Yes, my learner friend is correct.
बताइए
Page
इस
57.
पर्चा के बारे में क्या बोलूं?
वही तो दिखाना चाहिए. 107, page 57.
That is at page
Issue number
62.
6, 7 and 9.
Page
यहाँ से start हुआ discussion. 6, 7 and 9 का जो discussion, my learner friend is very correct. You will also just come to page 62. Page 61 का नीचे से page 7 para 17 is the ultimate finding. 62. 60. Sorry, page 60 से पहले बास्केट पर्चा के बारे में. Page 60 और ultimately para 17. Defendant number 1 DW6 has deposed 14/9/2018 and on 7/1/19 at the age of 65 years that she was married at the age of 18 years para 11. So on calculation.
आपका कुछ मैच नहीं करता, आप कौन से पेज नंबर से पढ़ रहे हैं?
यहाँ पेज 60 टू मैच करेगा.
60 में 16 का रोमन 7.
रोमन 7 के ठीक ऊपर में पढ़ रहे थे. Top. At
In
the age
this
of
respect,
65 years that she was married at the age of 18 years. So para 11, so on calculation the year of marriage comes in 1971, while in cross PW1 has deposed that Asira Beva, defendant number 1, has been residing in the land since marriage when she came para 7. Thus, as per PW1, Asira Beva, defendant number 1 has been residing on the suit property since she came after marriage in 1971. In this respect, proved document Basket Parcha dated 11th of February 1975 Exhibit B shows that Muhammad Hatim, husband of defendant number 1 and father of defendant number 2 and 3, and Muslim Mia, defendant number 4, were in possession of the suit property at the time of the issuance of 11th February 1975, while document E and F are supporting the facts of defense regarding current possession of the defendants over the suit property as also supported by PW1. Therefore, the defendants have proved by oral as well as the documentary evidence the facts of defense that Muhammad Hatim, defendant number 1 and father of such and such Muslim Mia, defendant number 4, were in possession of the suit property as the basket purchase dated 11th of February 1975 regarding the suit property Exhibit B was issued in their favor in the year 1975 and no so recently possession showing documents Exhibit D and F favorable to defendant number 2 and 3, both sons of such and such, and Muslim Mia defendant number 4, showing above named defendant number 1 are also issued by the competent authority, thereby continuity of possession of the defendants over the suit property has been proved by the defendant. Supporting these facts, the defendants have also proved that Asira Beva, defendant number 1, has been residing the suit property since they came after marriage in 1971. Further, Exhibit B, E, and F brought on record by exhibiting clause. The defendants have also the fact of tenancy being admitted by the defendants by necessary implication. This is important. Tenancy admitted by defendants by necessary implication. Furthermore, admitted the defendants were in possession of the suit property even at the time of the institution of the
ये privileged tenants.
privileged
Privileged. वो तो privileged tenancy act में है ना?
हाँ, Maharashtra. Then, above all, in para 26 of the claim says that the suit is valid such and
ये
such.
तो valuation.
Valuation पर नहीं जाना. Now, here also mechanism para 17. Ultimate finding. In the light of the above findings and discussion, it is concluded that the plaintiff has not only failed to prove the relationship of landlord and tenant between the plaintiff and defendant number 1 since July 1995 with respect to house on the suit property, but also the defendant number 1 stopped payment of monthly rent of ₹50 regarding the house on the suit property since January 2000, but also that the patta Basgit Parcha dated 11th of February 1975 Exhibit B issued in favor of Muhammad Hatim, the husband of defendant 1 and father of defendant 2 and Muslim Mia defendant 4, regarding the suit property described in schedule in the claim is antedated and forged document. Hence, the plaintiff has not successfully
So you failed to prove the relationship of landlord and tenant.
Number 1.
You failed to prove that there was any
You are
default consequently.
antedated basket purchase.
Antedated basket purchase.
These are the two findings not recorded in respect of the
You claimed landlord-tenant relationship.
Yes.
That is why you were claiming the property.
Claiming the property, but they set up the that is prior to basket purchase, that relation, and they set up the claim in
The
144
Basket Parcha was issued in
1975.
1970. You claimed that they were
95.
inducted as tenant from 1995.
1995. So
Yes.
Basket Parcha, which they have claimed, that has come for the first time in their so-called, which was filed in 144 proceeding,
Yes.
that is Exhibit 6, Exhibit 5, wherein the plaintiff could come to know that they are claiming their title on the basis
Limitation पे तो कहाँ dismiss हुआ?
limitation पर नहीं कर रहे. Now, Basket Parcha, the provisions of Basket Privileged Person Tenancy Act are to be followed, and that has been, that is Rule 5. It has not been proved how the Basket Parcha was issued. So the Basket Parcha, when it was under challenge, it was the duty
Bihar
income,
tenant,
Bihar privileged person.
privileged person.
Privileged Persons Homestead Tenancy Act and rules. Now, my lord, my humble submission for lordship would be that only mere marking of a document as a Basket Parcha Exhibit B does not show whether it was issued in accordance with law as
You see,
required under the law.
if there is a document issued,
Yes,
as per you said, that it is forged and fabricated.
forged and fabricated,
Forged and
and
fabricated,
the
it is
circle
one
officer
thing.
has no
It is
authority.
one thing to say. It is one thing to say that
So
the document has been wrongly issued by an authority.
That
It
is
is
also
another
the
thing
case.
to say
That
that
is
it
also
is
the
forged
case.
and fabricated.
And it was illegally issued, and it is antedated and forged. That is supplementary. Supplementary. So, but the original one is the Basket Parcha does not confer any right to identification. It was wrongly issued. This is our case, and that is my submission for lordship would be if Rule 5 of the said rule is taken into consideration, it should be the procedure has been prescribed, and whether the procedure has been followed, mere issuance of Basket Parcha would not be suffice to hold that it was the plaintiff has failed to prove that the Basket Parcha was antedated. Now, my lord, this aspect of the matter has not been considered by both the learned courts. This is the only point, my lord, which I can raise at the moment. Because otherwise, my lord, the lordship will kindly see the appellate court judgment also.
Did you prove how were you claiming your title?
My title is,
Yes.
that is 5/1/1938, that is the common document filed by both the parties. That is Exhibit 1, by which Wahid Ali sold Takta 7 Kata 17 Dhur to the father-in-law of the petitioner, plaintiff. Then, Lord, on 22/8/1974, father-in-law sold it to the plaintiff, the suit premises, by registered sale deed 22/5/1974, that is before Basket Parcha. Now, the provision of the Basket Parcha Act and rule says that there must be a hearing of the persons who is title holder. No notice was issued. Secondly, Rule 5 says there must be an inquiry by a person not below the rank of circle inspector. That has not, these two aspects have not been taken into consideration by looking into the provisions of Bihar Privileged Person Homestead Tenancy Act and the rules framed thereunder. Whereas both the learned courts proceeded that the plaintiff failed to prove that it is an antedated and forged and fabricated document. The right from the very beginning in the plaint, the case made out by the plaintiff with regard to challenging and assailing the Basket Parcha in the suit. So far, my lord, since it has not been held that it is barred by limitation, but the question remains that the one of the issue that is related to Basket Parcha is issue number 9. So issue number 9 has not been properly appreciated in the touchstone of the provisions of the Act and the rules framed thereunder. These are my summaries. Your Lordship, may I can refer to the appellate court judgment. Your Lordship may kindly see in this regard, para 41.
When you say that you see it was forged and fabricated, तो आप क्या हम prove करें? Forgery is another thing. Jurisdiction is another thing.
Jurisdiction. The first page 41 of the appellate court judgment. Lordship may kindly see. Page 14, most probably the page is telling me. Not, I am very sorry. Page 31, para 29. 41.
That is page, the internal page.
Para 31. Para 31.
Internal page?
Internal page जो नीचे लिखा हुआ page 32.
Who has got the authority to issue the basket purchase?
Your Lordship may kindly see one of the provisions. Rule 5. First of all, I will refer to Rule 5.
आप किसकी तरफ से?
हम यहाँ पर
Defendants.
You are representing all the defendants.
Rule 5.
आपका कौन सा substantial question of law? आपका कौन सा substantial question of law?
जी, Rule 5 of मेरा.
आपका कौन सा substantial
अच्छा,
question?
sorry. बहुत चार इशू लिखे हैं, इसमें से एक ही बास्केट पर्चा से रिलेटेड है, जो हम I'll just small a, small a and b, those can be clubbed together. Rule 5 says it is not by the circle officer or circle inspector, that is mandatory in nature, held by several judgments of the Honorable Patna and Mediation.
Rule 5.
Rule 5. Rule 5 will you get it? The collector shall either himself make local inquiry or have such inquiry made by any responsible officer not below the rank of a circle inspector or welfare inspector and satisfy himself as to the correctness or otherwise of the contents of such application. The inquiring officer shall issue a notice in Form F to all interested parties intimating the date on which the inquiry shall be made and directing the parties to produce all the evidence in their possession in support or against the application. The inquiring officer shall make a record of the evidence produced before him. The collector shall, after hearing the parties on all points arising out of the such and such application, pass such order as to him seems to be just and proper. Then collector shall prepare a record of homestead held by the privileged tenant in Form G. The main record shall be maintained. None of the procedures could be established by the defendant to support their case of basket purchase, nor the learned courts had taken pain to look into the provisions which are mandatory in nature. This is the only law point which I can raise at the moment. So far, provisions of the Act is concerned, Your Lordship, just see. First of all, the inquiry of the collector has to satisfy whether he is a privileged person within the meaning of section 2 small j. And thereafter the procedure
कब दिया है पर्चा?
1975 हम खरीदे हैं 71 में, पोजीशन इनको दिए हैं एज ए टेनेंट, और सेक्शन 3 कहता है क्या हुजूर, देखा जाए थोड़ा देर के लिए, सेक्शन 3 एक्ट नॉट टू अप्लाई टू सर्टेन लैंड्स बिल्डिंग और एरियाज, दिस इज अ हाउस, दैट इज एन एडमिटेड केस, एनी लैंड और बिल्डिंग रेसिडेंशियल और अदरवाइज डज नॉट अप्लाई. And then, Lord, the procedure prescribed, Lord, section 8 is the grounds, and lastly,
You were claiming on the basis of your title deed.
yes, registered title deed, that is not denied. The original title deed they did not deny. Registered title deed in favor of my father-in-law. Thereafter, I got it from father-in-law by registered deed, and they claim that we are in possession. Therefore, we applied for basket purchase. We were granted basket purchase in 1975. So we are not the tenants.
Okay. Second appeal number 274 of 2023. Heard the counsel for the appellant. The learned counsel for the appellant has submitted that there are concurrent findings recorded against the appellant, but the appellant had challenged, was claiming property by virtue of registered sale deeds
Yes.
and had sought a declaration that the Baski Pacha issued in favor of the defendant under Bihar Privileged Persons Homestead
Tenancy Act
Tenancy Act
1947.
1947 was not issued in accordance with law and as per the provisions of the said Act.
And the rules
He
state
submits
there.
that, and the rules framed thereunder. He submits that the learned courts have not examined as to whether the procedure in connection with issuance of basket purchase was duly followed or not. After hearing the appellant, this appeal is admitted for hearing on the following substantial question of law. Whether the learned courts have erred in law in not considering as to whether the required procedure for issuance of basket purchase ये A and B ही कर सकते हैं, इससे हो जाएगा.
Yes.
A and B कर.
Yes. Yeah.
The respondents have already appeared.
Your
Let the records be called for from the concerned court. Let this order be communicated through fax. Post this case for final disposal on 11th August.
Sorry to detain you.
आपका केस सेकेंड हाफ नहीं हो पाएगा. आप जरा क्वेश्चन ऑफ लॉ ही हमको समझाइएगा क्या क्या फ्रेम करवाएं.